Chair, our witness today is General Johan Booysen, who's ready to take the
Please state your full names for the purpose of the court.
Good morning, Madam Chair. It's Johan Booysen.
Will you take an oath or affirmation?
I will take the oath.
Will you swear that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God.
I do so help me God.
Okay, welcome Mr. Booysen, together with your legal representative, Mr. Katz, and over to you.
Chair, perhaps before I start, just one small matter of housekeeping. There was some misunderstanding, I understand, of the course between Friday and this morning about which witness would be there this morning. I've agreed with Mr. Answer that we'll start Mr. Booysen's evidence, and then he may well need a bit of time to prepare his cross-examination, but we'll deal with it at that point, if that's convenient.
Is that in order, Mr. Answer?
Yes, Madam Chair, I don't have a choice. We certainly will. We were expecting Mr. Booysen tomorrow, and Mr. Hoffman this morning. Some of the backing order was changed. That is because of my involvement in the cricket. We do it all the time to surprise the opposition. But I'm sure there's no other motives, and I think to deal with it on that basis, we may even be able to, I'm not unfamiliar with what Mr. Booysen is going to say. I've read it, seen it before, so we may ask for a short adjournment to discuss one or two things, but I don't think it should obstruct the rest of the day too much.
I think you are quite correct. We went home knowing that we're going to hear Mr. Hoffman today. But when we saw the changes, we assumed that there was an understanding between the two sides. And for that reason, we were not perturbed. Yes, but I'm glad that you have sorted matters. We appreciate that. Thank you. We have Mr. Mamabolo. Do you have anything to say? Oh,
It's Ramawele. Ramawele, yes.
Okay, Rama.
I do not think the witness will say anything about Advocate Mrwebi unless there is a surprise, which we'll be ready to deal with. Thank you.
That's good to hear. Thank you. Okay, I think we can go ahead. Proceed. Thank you.
Thank you, Chair. We apologize again for the inconvenience. General Booysen, you were here on the request of the evidence leaders today to give evidence, is that correct?
That is correct.
And just for the record, you're here with your counsel, Advocate Katz, SC?
That is correct.
And Advocate Katz is here, I understand, because you're still facing criminal proceedings in another court. And so he will make sure that you give us the right answers.
I'm still the choir master.
That's me, sir.
You might not know, we have a choir master here, and her main job on this panel is to ensure that everybody speaks sufficiently loudly and into the mic. There's a tendency to relax at some stage and then sit back, and we can't hear what you say. So kindly, everybody, you speak up and you speak into the mic. Thank you.
Thank you. I'll do my best. I'm battling with a bit of a cold, but I'll try and speak loudly so you can hear me clearly. So General Booysen, let's begin by confirming that you're here giving your evidence freely and voluntarily, notwithstanding those criminal proceedings that are pending. Is that correct?
That's indeed so, Madam Chair.
And for the record, the purpose of this inquiry is not to to make any finding in relation to your guilt or innocence on those criminal charges, you of course have a right to be presumed innocent, and you would be entitled to, you have a right to silence, and be entitled to waive that right to the extent that you wish to do so by giving evidence today. And Mr. Katz will guide you in the exercise of those rights.
And that is my understanding, Madam Chair.
Now, General Booysen, you've made two affidavits that are before this inquiry. The first is the founding affidavit in the KZN High Court, which is to be found at folder G, item 5.1.4. And the second is the affidavit that you made in December 2018 for purposes of these proceedings. That is to be found at folder M, and it's item 1. Now, General Booysen, for your purposes, you've got two files there. You'll see that the smaller file with less paper is your affidavit for purposes of these proceedings and your annexures. You got that?
Do you have that, Madam Chair?
And then the second file is what I'll call the miscellaneous file, and it has a series of documents that are evidence before this commission that concern your case.
I confirm that, Madam Chair.
Now, can I start by confirming that the affidavit that you prepared, that's dated December 2018, was prepared by yourself? Is that correct?
That's the one in the smaller bundle? That's indeed so, Madam Chair.
And so, when we spoke earlier, you indicated to me that there were some typographical errors that you wish to correct in that affidavit. So perhaps as we go through it, you let me know where there's something that you wished to correct.
I shall do so.
Save for that, can you confirm the accuracy of those two affidavits that I referred to this morning?
I do, Madam Chair.
All right, let's begin by looking at your qualifications and credentials. I understand that you have a degree in policing, is that correct?
That's correct, Madam Chair.
And what other degrees or diplomas do you have?
I do have a national diploma in policing, police administration. I've subsequently obtained my police degree. And post that, I was chosen to be on a presidential leadership program with the Northwest University, where I did a qualification equivalent to an honours degree, Madam Chair.
And I understand you were trained in racketeering investigation in the United States, is that correct?
Well, I've been trained by an attorney from the United States in South Africa. The training took place in South Africa.
Okay. At the moment, General Booysen, you've retired from the SAPS, is that correct?
That's correct.
When did you retire?
I retired in 2016, Madam Chair.
And when you retired, what rank were you at?
I held the rank of Major General.
Okay. If I can now take you to paragraph 12 of your affidavit in the KZN High Court. It's going to be pulled up on the Dropbox for you. It's folder G, item 5.1.4. Just give them a minute to find it on the Dropbox so it comes up on the screen.
Whereabouts would that be in this
And we'll
file?
have a look at it on the screen. It's folder G, item 5.1.4. Thank you, and I'm looking at paragraph 12.
Maybe a bit difficult to find this file. I don't know the flags in gold.
Can you see the affidavit up there, or we'll get you a hard copy of this here?
I can see it, Madam Chair.
I'm going to take you through what it says there, and I'd like you to confirm if it's correct or not. This is a summary of your experience. It says that you joined the SAPS in 1976 and have served for an uninterrupted period of almost 40 years. Is that correct?
That's correct, Madam Chair.
And then in paragraph 14 it says that you were arrested on the 22nd of August 2012 on charges which relate to the conduct of certain members of the Katomina Serious and Violent Crime Section, which was a section of the Durban Organized Crime Unit. Is that correct?
That's correct, Madam Chair.
We'll come back to your arrest, but to take a step back, tell us about your trajectory through the SAPS. I understand you joined as a patrolman.
Madam Chair, when I left school in '76, I joined the South African Police Services. I was initially a patrolman, after which I became a detective at the General Detective Branch.
And what happened thereafter?
Later on, I went to crime intelligence for a short while, after which I became an officer, a commissioned officer. I was then the branch commander of a detective branch in Durban at Brighton Beach. Subsequent to that, I became the second in charge of the then murder and robbery unit, after which I became the commander at the Durban murder and robbery unit. And during 1995, with a new dispensation, I was appointed as the provincial commander at the time for priority crimes at provincial level. Subsequent to that, I became the head of organised crime in KwaZulu-Natal, and eventually I became the head of the Hawks, the DPCI in KwaZulu-Natal.
Thank you. So at the time that you resigned, you were the head of the Hawks, head of the DPCI. Is that the correct way of referring to it?
Madam Chair, I did not resign. I was actually offered 3 years prior to the termination of my career. I was offered a golden handshake, which I refused. Events took place after that, and about 6 months before my actual due retirement date, because of certain litigation that had been going on at the time, I agreed with the police that they would release me with full benefits. So I effectively left in February of 2016, whereas I was supposed to have left in July 2016.
I'm going to ask you to turn off your mic when you're not speaking, just for purposes of the recording. Thank you. General Booysen, as part of the evidence that you'll give today, and as part of the evidence that's contained in your affidavit, you make various statements about the nature of investigations that you worked on, the nature and content of the docket that was prepared against you, and the charges against you. So I'd like you just to first give this inquiry some sense of your experience in relation to the things that you comment on in those affidavits. Would you say that in your 40 years of experience that you have extensive experience of conducting investigations, police investigations?
I do indeed, Madam Chair.
And compiling dockets?
I do indeed, Madam Chair.
What has been the nature of your work with prosecutors?
Madam Chair, I have interacted over a period of, I'd say, probably about my entire police career since I've been a patrol person. I've testified in the magistrates' courts, regional courts, high courts in different places in the country, and I've also testified previously in 2 commissions of inquiry. So I have interacted extensively with prosecutors over the entire span of my career.
So would you say that you had a good knowledge of what a docket looks like and what should be in there?
I do, Madam Chair.
And as I understand the process, the SAPS would prepare the docket and then send it off to the prosecutors to determine whether or not charges should be laid. Is that correct?
Madam Chair, what actually happens as a branch commander of a detective branch, the branch commander in terms of police standing orders, before the docket is submitted to a public prosecutor for decision, the branch commander would peruse the docket and ensure that all available evidence in that docket, in terms of chain evidence, in terms of all the relevant statements, ballistic reports, etc., are indeed in the docket. He will then certify in the docket to the prosecutor that the investigation is indeed complete, and he will then forward it to the prosecutor for decision.
Okay. And more than that, do you expect anything from the prosecutor in terms of a relationship or ongoing relationship with the SAPS in terms of what's in the docket?
Madam Chair, in my experience as a young officer a good many years ago, I would certify the docket to the prosecutor. And At times, and that would normally happen with inquest dockets, where there would invariably be queries from the prosecutor. Now, at that time, to me, I almost deemed it as a challenge to send the docket to the prosecutor and let the docket come out with those queries. But invariably, from time to time, and more so today, dockets do come back from prosecutors with extensive inquiries as to certain aspects in that investigation that needs to be followed up or clarified.
Thank you. Now, if I can take you to your founding affidavit in the KZN High Court, which will come up on the board. We're trying to get you a hard copy to make it a little easier. But for now, if you could look up at the screen. Paragraph 14 of that affidavit. We said earlier that you were arrested on 22nd August 2012, and on 5th February 2013 you were indicted. Is that correct?
That's correct, Madam Chair.
If you could go to paragraph 15 of that affidavit. The charges, I understand, related to contraventions of sections 21E and 21F of the Prevention of Organised Crime Act. Is that correct?
That is correct.
And that colloquially is called racketeering. Am I correct?
That is indeed so.
What is the penalty for racketeering?
Madam Chair, the penalty for racketeering is, upon being found guilty, life imprisonment or R1 billion fine.
Thank you. You bear with me for a minute. Now, General Booysen, just so that the panel understands where things presently stand against you, can you give us a brief idea of what has happened since you were charged with the contravention of POCA? You say in your affidavit that you reviewed, and this affidavit for the KZN High Court was to seek to review and set aside the decision authorizing your prosecution. Is that correct?
That is correct, Madam Chair.
And that decision was taken by Advocate Jiba. Is that correct?
That is indeed so, Madam Chair.
And what was the outcome of the KZN High Court application?
Madam Chair, Judge Gorvin J. ruled that the decision to prosecute me was irrational in terms of the principle of legality. It was unconstitutional, it was set aside, and subsequently all charges were withdrawn against me in the High Court of KwaZulu-Natal.
And then if I can take you to your affidavit in the smaller of the two files, that is the affidavit which is prepared for purposes of this inquiry. If you look at paragraph 6 of that affidavit, it's page 3 of that bundle. In paragraph 6 through to 8, you describe the process by which the prosecutor, Advocate Mlotshwa, was asked to authorize charges against you. I don't want you to go into that because that's not peculiarly within your knowledge. But if you turn over the page to paragraph 9, can you explain to us there, you say that on the 29th of October, this is now part of your criminal charges. You were charged and you then appeared on the 29th of October in the Durban Regional Court. Is that correct?
That is correct, Madam Chair.
Okay. And then you say that the prosecutor, Mr. Selo Maema, discovered the evidence that was in the case dockets to you. Is that correct?
That is also correct.
And to your lawyer?
That's indeed so.
And there were 23 dockets in the case in the case made against you. Is that correct?
That is correct.
Okay. You then say the matter was remanded to the 5th of February after Advocate Maema informed the court that all the evidence in the state's possession was discovered to you. Is that correct?
That is correct.
Can you explain to us what you did thereafter? It's contained in your affidavits from paragraph 10 through to 14.
Madam Chair, to start off with, when the dockets were discovered to us, they were in a bit of a disarray. And I had concerns that there might be evidence or statements that could have been left out. So I decided to embark upon compiling an inventory of each and every item in those dockets. Statements, correspondence, whatever was discovered to us. It took us quite some time to do that, and we reduced that into writing, which we eventually sent back to Advocate Mahema to confirm that we have detailed an inventory of each and every item in the dockets that were discovered to us. And we actually send him a list of that inventory.
And what, if you look at paragraph 11 of that affidavit, you say it's evident from the inventory that you referred to now that there were no statements from Aristanikas, Rayendran Eyre, and Beki alias Londlo Mtiani that formed part of the statements that were discovered to you. Is that correct?
That is correct, Madam Chair.
And in paragraph 12 of that affidavit, you say that your name only featured in 2 of the 23 dockets, a Howick case and a Durban North case. Is that right?
That is indeed the case, Madam Chair.
Now, if we can just turn for a minute to look, you go on in your affidavit and you talk about the specific statements that were contained in each of those cases, the Howick and the Durban North case. In the Howick case, you say in paragraph 13, you were mentioned in 2 statements. Is that right?
That is right.
And the 2 statements were that one was of Captain Subha Naidu, which is in Annexure B, which is in your file.
That is correct.
And the other was Andrew Carson Cochrane, which is Annexure C in that same file.
That is also correct.
Okay, let's go to the statement B, which is the statement of Captain Naidu, which is B in that file. That is to be found, Chair, at page 123 of the affidavit bundle. Have you got that page?
I do, Madam Chair.
All right. Now, this statement refers to an incident where you used a police helicopter to attend to a crime scene on the highway. Is that correct?
Madam Chair, I'll try to rephrase that. I attended to a shooting incident on that particular day using a police helicopter.
And Captain Naidu says in paragraph 3 of his statement, as I got closer, I noticed the scene abuzz with police. There was a police helicopter on the freeway. I didn't know the facts of the case at that point, but noticed a few senior officers, including Director Booysen, on scene. I parked my vehicle and approached police officials from my station and inquired as to what had happened. I was informed that the police had shot 2 suspects. The crime scene experts were already on scene. I was not the duty officer, but as the incident occurred in my precinct, I was requested by someone, I cannot recall exactly who now, to compile the shooting report, which I duly did. Can you see that?
I do, Madam Chair.
Is that the only reference to you in that statement?
That is the only reference to me in that statement, Madam Chair.
Can you explain to us why would you have used a police helicopter and why did you attend this particular scene?
Madam Chair, as I've said earlier on in during my police career, I've been in the command position over periods of time. There is nothing untoward in attending to a shooting incident. As a matter of fact, I've done hundreds of those all over the province in KwaZulu-Natal. The provincial commissioner at the time actually expected of me at the time to go to incidents like this, and wherever time and circumstances permitted, I would go to the scene. Normally, if it's in close proximity, I would make use of a vehicle, but in this particular instance, to get to the scene quicker, I used the police helicopter.
Thank you. Was there anything unusual about this? You said that you do use the helicopter. Was there anything unusual about this particular incident?
Absolutely not, Madam Chair.
Okay, and then can you go to Annexure C, which is at page 126 of your affidavit bundle. This is a statement of Andrew Cargan Patrick Cochrane, is that right?
And that's right, Madam Chair.
And it would appear from the affidavit that I don't know if he's a captain or Mr. Cochrane, is one of the crew in the SAPS Air Division. What is the correct way of referring to them?
Madam Chair, he was the crew, he was Warrant Officer Cochrane, and he was the crew of the helicopter being flown by Captain Rafilwe Ledwaba.
What's the role of a crew on that helicopter?
Madam Chair, the role of the crew is to lighten the burden of the pilot with air traffic control, talking with radios to personnel on the ground, and also to be an extra eye for hazardous obstacles like wires that they could possibly fly into.
Now you'll see in that, lower down in that affidavit, it looks like the numbering of those paragraphs have gone awry. They're 3 paragraph 4s. If you look at the third of the paragraph 4s, it says, I would like to clarify that Durban Air Wing Unit is at the old Durban International Airport, and on our arrival at the airport, Director Booysen and Superintendent Lafur jumped inside the helicopter and we headed to the N3 highway near Howick. Is that correct?
That is correct, Madam Chair.
Why was Superintendent Lafur with you in the helicopter?
Madam Chair, if I could explain, Colonel Lafur was the section commander of the Durban Organised Crime Unit situated at Katomina. The members that had been involved in the shooting reported to him. He in turn reported to a Colonel Eyre, and I was informed that there had been this shooting incident at Howick. I first of all phoned Lafur and said to him that we should go and see what had occurred there, and I undertook to pick him up in my vehicle. So on my way to the Katomina office, and if I say Katomina office, Madam Chair, I'm referring to the Durban Organised Crime Unit. It's only called Katomina because of where the offices are located. On my way to his office, I realized that it was going to take me a considerable period of time to get to the incident at Howick. I then phoned the air wing and I inquired as to whether a police helicopter was available to transport me to the scene. They confirmed that. The helicopter, understood at the time, was busy with crime prevention duties in the Durban CBD area. The arrangement was that I would drive to the air wing and they would land and pick me up. I drove straight to the air wing. I picked up Lafur first. Drove straight to the air wing, parked my vehicle. We ran across the apron. I could see the chopper coming into land. The pilot did not cut the engines. We jumped in the chopper, and from there we flew to Howick.
Okay. In paragraph 14 of your affidavit, you then move on to the Durban North case, which is the second of the 2 cases in which you are mentioned in the dockets. You see that?
That would be the statement of Shamila Williams.
That's correct. That refers to a statement of Shamila Williams, and it's Annexure D, which is at page 131 of that witness file. If you could go to that. Have you got it?
I do.
All right. This statement is a little bit longer, but let me take you through it. So it says in paragraph 2 that Shamila Williams is an investigator at the ICD. Is that correct?
That is correct.
Okay. And in her affidavit, she goes through a series of crime scenes that she attended on that day that appear to be related. Is that correct?
That is correct.
And if you go through to paragraph 8 of that affidavit, which is at page 133, that appears to be the first time that you are mentioned. Am I right?
That is correct, Madam Chair.
Okay. So in paragraph 8, she says, I also noticed Constable Pedro Rodriguez at the scene, and later Ms. Mpanza informed me that there was another deceased that was found at a nearby house, and it was the owner of the residence where the scene was being processed. I later noticed General Booysen at the scene, and he confirmed with me whether ICD was properly briefed about what transpired. I checked with Captain Lockham, as he was the organized crime officer at the scene. You see that?
I do, Madam Chair.
What were you asking her to do when you asked her whether ICD had been properly briefed?
Madam Chair, in every single shooting incident where police members are involved in, and which I'm aware of, and the record will show that, normally the first question I would inquire about, obviously, if people have been injured where the ambulances or paramedics have been summoned, and the very next question always would be, has the ICD at the time, which are now IPID, whether they had been informed. On this particular occasion, I arrived probably about 4 or 5 hours after this particular shooting. I arrived on the scene. I did not enter the scene proper. I was merely standing on the pavement. I'd never met Ms. Williams before. I'd spoken to her on the telephone before, and when she was introduced to me, I still said to her, at least I can put a name to the face now. And then I asked her whether she had been properly briefed, which she confirmed she had been.
Thank you. So these 3 statements that we've now gone through were the only reference to you in the dockets, the 23 dockets that you were provided with in discovery by Advocate Maema. Is that correct?
That is correct, Madam Chair.
Can you explain to us at some point thereafter, at successive hearings of when your matter was called again, you were told about additional information that was that contained part of the docket. Do you recall that?
I do, Madam Chair.
Can you take us through that? Do you want me to point you to your affidavit where you detail that? If you give me a minute. If you look at paragraph 19 of your affidavit, there was some concern about the fact that there were additional statements by Colonel Eyre, Mr. Danikas, and someone whose alias was Londlo, Mr. Mtiani. You recall that?
I do, Madam Chair.
Did those statements form part of the docket?
And they did not, Madam Chair.
When were you provided with those statements?
Madam Chair, if it's possible just to explain the sequence of how I became aware of those statements. When the evidence was discovered to us, I think it was in August or October, by the lead prosecutor, Advocate Mahema, he confirmed with the magistrate, the regional court magistrate at the time, and we pertinently asked the question in court, is this all the evidence? Which he confirmed. But he did tell the magistrate that if new evidence comes to light, it will be discovered to the defense. Subsequent to that, we were indicted in the High Court, and I think it was in February the following year. Advocate Mahema then told my attorney, Mr. Carl van der Merwe, that they had not discovered everything, and he handed him a handwritten note of evidence that they still wanted to discover to us. And 2 of the names on the list inter alia was one Colonel Rajan Eyre, and the other one was of a person by the name of Beki Mtiani, nickname Londlo, alias Londlo. That letter was given to my attorney. My attorney confirmed in writing the following day via email to Advocate Mahema that evidence was still outstanding. Subsequent to that, during my review application, at the time of filing my founding affidavit, that evidence had still not been discovered to us, and that is contained in my founding affidavit. I actually mentioned that. Subsequent to that, in May that year, Advocate, we were then once again in the High Court.
You said in May this year?
No, Madam Chair.
I didn't hear properly.
Sorry. So, yeah, the following year. So, in May, so February, we were given the handwritten note that this evidence was still to come. It didn't come until such a time that the answering affidavit was filed. During May that year, and at that juncture the name Danikas was never mentioned. In May that year, and I can recall vividly, I asked my attorney Calvin Mrwebi to now ask Advocate Mahema, is this now all the evidence? And Advocate Mahema confirmed to the judge that this was all the evidence, but then he got up and he said, except there's one statement that they're still busy trying to obtain through mutual legal assistance from a Mr. Danikas from Greece. And that was the very first time that the name Danikas appeared.
So those statements are contained, I just want to take the panel to those, they're contained at page 160 of the affidavit bundle. 160 is the first statement by Colonel Eyre, otherwise known as NJ2. It's referred to that in Advocate Jiba's affidavit, NJ2. That's page 160. And that affidavit was made on the 3rd of August 2012, is that correct?
That is correct, Madam Chair.
And then Colonel Eyre made a second statement on the 31st of August 2012. That's at page 164 of that bundle. You see that?
I do, Madam Chair.
And then the statement of Danikas is at page 170 of the bundle, which is it's referred to in the affidavits as NJ3, page 170 of this bundle.
Madam Chair, it's actually a document purporting to be a statement from Danikas.
That was my next question. Is that a signed statement?
It is not signed and neither is it dated, Madam Chair.
Was a signed statement ever provided?
No, Madam Chair.
Okay. And then at page 176 of that bundle, you'll see a handwritten statement by Bekinkosi Mtiani, and he's known as Dlondlo. Is that right?
And that's right, Madam Chair.
Okay. Now we'll come back to the import of those statements in due course.
Do we know what the document entailed? Can you just put it on record here?
Sorry, Chair, do you mean the contents of those statements?
What it entails, only what it entails, not what is it about.
Yes, could you tell us, let's go through them now then. So General Eyre's first, Colonel Eyre's first statement, which is at page 160.
You don't have to tell us what the contents are, just what it is about.
What were the three statements? Can you just give us a general summary of what they dealt with? In your affidavit, you described General Eyre's statements as being office politics. Can you elaborate?
Madam Chair, indeed, Eyre made two statements. They're actually very convoluted if you read them, and very incoherent to start off with. But nevertheless, it pertains to office politics. It does not link me to the commission of any offence, directly or indirectly, for the offences that I've been charged with. And it's not only myself that is saying that Judge Gorvin, the matter, the acting NDP versus Booysen, actually confirmed that particular statement, well, neither of the two statements, he actually confirmed that it contains, it relates to office politics and does not implicate me in the commission of any offence.
The affidavit, the statement of Danikas. Can you give us a sense of what's contained in there? Do you want me to take you to the relevant bits? It's at page 170.
Madam Chair, this particular statement, purported statement, which is not signed, neither dated, contains a whole lot of allegations.
Is that now what you refer to as a document and not a statement?
That's correct, Madam Chair.
I think that is the only document that I needed to hear what it entails. Okay.
Apologies, Chair. Let us then look at that document by Mr. Danikas. It says that Mr. Danikas was a close family friend of yours. Is that right?
That's right, Madam Chair.
Okay. And this statement was purportedly taken. Mr. Danikas is in Greece at the moment.
That's right, Madam Chair.
What is he doing in Greece? Do you know?
Madam Chair, I don't know what he's doing in Greece, but I do know why he left South Africa.
Do you want to elaborate?
Madam Chair, Danikas was a reservist at the time reporting to me. At the time of him reporting to me, I would regard him as almost like he wanted to be a Miami vice policeman. He would do his own little things at night after hours, phone me at odd hours, getting involved with investigating narcotics. At times he would get beaten up. At times he would make arrests. Nevertheless, he was eventually promoted to the rank of sergeant, and then he started pestering me. He wanted to become a captain, and the more I explained to him, Ari, it's not like in the movies where you do something good, you get a sheriff's badge, and now you're a captain. So, but this carried on for quite some time, and eventually I explained to him, look, Ari, you need to understand, in the new dispensation, we also have affirmative action with the reservists. Then he told me, well, he's going to go to the media. Then I pleaded with him not to do that because it would embarrass me as well. In the end, he went to the media, and there was an article in the newspaper where he lamented the fact that he was not being promoted. I cannot recall whether he referred to the affirmative action part of it. I'll have to read the article again. But nevertheless, he had then brought the police into disrepute. And I had a duty as a manager to then suspend him. And I'd sent someone to his house to retrieve his state firearm, which he understood was not very happy with because it was done in front of his fiancée. But over and above that, Madam Chair, over a period of time, he ran a computer store in the central of Durban, close to a college of which most of the students were black people. Now, Derek has been a Greek citizen. I would from time to time come to his store, and there would be arguments between him and some of his clients, and it would relate to the selling of computers to the clients. But then he would have a board on the front there saying, sold food stewards. And I still said to him, Ari, you cannot do this which you are doing, selling the computers that break down and then tell him, you're selling at food stewards. At a later stage, there was so much confrontation between him and some of his clients, he was actually wearing a bulletproof vest and going to the office. He had a lady working with him, and I cannot recall her surname, her name was Zonke. Now, I knew Zonke because I would come to the shop every now and then. Then Ari told me that he wanted to sell the business for 5 million rand. I still said to him, Ari, you're never going to get 5 million rand for this business. But he tried to convince me that's what it's worth. He then told me that he had gotten Zonke to invest 300,000 rand into his business. I made nothing of it because the business was ongoing. Then on a particular day I received a call from, I cannot recall from whom, asking me, where is Ari? And I said, well, it's about 10 o'clock in the morning. I said, well, he should be at his shop. A couple of minutes later I received a similar call, Ari is not at the store. So I decided to drive out there to go and see what was happening. On my arrival there, I found Zonke, the guy next door, an Indian chap who owned the pie shop, and they were standing there. They said to me, Ari never pitched for work, and the shop is empty. And I said, what do you mean the shop is empty? Zonke then related to me that Ari had told her and the other black gentlemen that worked for him that they should stay away from work for a week, and that Mesa was going to refurbish the store and that they should then come back. So they stayed away for a week, and when they returned, the shop was empty. Looking from the outside, all the boxes were still there. But the complete storeroom with all the laptops, cameras, computers, everything was missing. And I tried to get hold of him, and I couldn't get hold of him. Later that evening, I received a text message from him in which he said, Hela Mitso. That's the way the Greeks greet each other. He said to me, had to run like a goat. He was complaining about the safety issues in South Africa and the fact that his father was sick. And that's the reason why he went overseas.
Now, General Booysen, this document by Mr. Danikas, as you pointed out, is not signed. It contains various allegations against you and makes very serious allegations about your conduct in relation to particular incidents at that shop that you mention. Because it is unsigned and because potentially it's something that you'll have to deal with in your criminal proceedings, I'm not going to ask you anything more on those particular allegations. You may be cross-examined and you can deal with it then.
Madam Chair, the statement was signed on the 24th of October 2016. It was disclosed in the answering affidavit in the pending review matter of Naidu, which concerns the second decision to institute a prosecution taken by Mr. Abrams, which is now the subject of a review. Ms. Bauer asked us for that affidavit. That was sent to her, I think it was in December, early January this year, together with a copy of the signed statement.
Thank you, Chair. I'm not aware of that signed statement, and I see Mr. General Booysen's counsel shaking his head. Can I ask him to respond?
Madam Chair, let me explain it this way.
Yes.
It's now 7 years down the line. We still do not have a signed statement of Ari Danikas, as recent as November last year. And the paper trail of emails from my attorney, Carl van der Merwe, will confirm that. As recent as November last year, that statement had not even, and that's in the own words of Advocate Mahema, had not even been translated yet. Now, the problem that I also have with that, Advocate Abrams in his affidavit says that the statement had now been signed. And based on that, he authorized my second prosecution. Now, unless he's conversant in Greek, which I doubt he is, I don't know how he managed to consider Danikas' statement, which up until November last year had not been translated, and I can produce the evidence in that regard.
Do we know when the statement was signed?
Chair, if you, with your permission, we'll try and find out. If my colleague said that they provided it to Advocate Bauer, we'll contact her and just find out whether she received that and where that is. And if you wouldn't mind, I'll then return to it in due course once we determine that.
Madam Chair,
Yes,
just a correction. At 78.2 of the affidavit, 8.2 of the affidavit reads that the statement has since been signed.
Affidavit by who?
By Ms. Jiba.
Oh.
The statement has since been signed on 24 October 2016 and has been translated from Greek to English by the Department of Justice.
2016?
2016, 24 October 2016. But it doesn't appear from the affidavit that the signed translated statement is attached.
Okay.
Madam Chief, I can just perhaps add to that. In any event, that relates to the Naidu applicants, not to the Booysen application. But be that as it may, as we stand here today, that statement, a signed English version, has not been discovered to us, in spite of a number of requests to Advocate Mahema. It might have been signed in Greek in 2016, but in November last year, barely 2 months ago, Advocate Mahema still confirmed, and even says in his writing he doesn't understand Greek either.
Okay. So, as things presently stand, we don't have a signed version. Sorry, Chair?
I was saying thank you for that information. Yeah, you can proceed.
So, as things presently stand, we don't have a signed version in the evidence before this inquiry.
We don't, Madam Chair.
Okay. Now, General Booysen, I want to look at another topic now. You were in the midst of conducting several, two in particular, quite sensitive investigations at the time that you were arrested and charged, as we've just described. Can you describe that to us, those cases?
Madam Chair, the first one relates to an investigation which I initiated against a wealthy businessman in Mhlanga Rocks, KwaZulu-Natal, Mr. Toshan Pandey. It related to the acquisition of accommodation and various other logistical items during the World Cup soccer. The initial investigation indicated that there were serious irregularities with regards to the acquisition of certain contracts. The initial indications showed that there were 15 million rand that had business that had been given to him where the rules were not followed. Subsequently, it turned out that the amount actually increased to 60 million rand over a period of 8 months.
Given to him by who?
Madam Chair, what happened is we had a Colonel Naveen Madhu who worked at procurement, supply chain management at the police headquarters. Although he did not authorize it, but he recommended the contracts, and they flouted a number of treasury rules in the process to acquire these contracts. That is the one investigation, Madam Chair, and I can perhaps elaborate later on what happened afterwards with that investigation.
General Booysen, if I can interrupt you, if you look at paragraph 1 of your affidavit, you referred to that investigation.
Which paragraph?
Paragraph 1, on page 1 of the smaller bundle.
That's correct, Madam Chair.
Okay, can you perhaps, you've given us a sense of what the investigation concerned. You then refer halfway down that paragraph to an attempt to bribe you. Can you explain to us what happened there?
Madam Chair, various things happened. Within a week or two after the investigation commenced, I was called in by the then Provincial Commissioner, General Mamunye Nkobeni, and instructed to stop the investigations. Various incidents took place after that. I was called to an office on a number of occasions with the main suspect, Toshan Pandey, being present, and where I had been interrogated about the investigation. Nevertheless, I had agreement then with the then national head of the Hawks, General Anwar Dramat, that we would continue the investigation and that I would let the investigators report to his office directly to take the pressure off me in the province. There were attempts to have Section 205 subpoenas that we had acquired set aside. We had opposed that successfully in the High Court.
General Booysen, just to take you slowly through this, please. You said that there were attempts to have Section 205 subpoenas set aside. Can you explain to the inquiry what those are?
Madam Chair, what happened is the investigators needed to access the banking details and obviously sell records of the suspects in this matter. And in terms of Section 205 of the Criminal Procedure Act, we summoned that particular information. That subsequently, with that information on hand, we were in a position to apply for search warrants. So we applied for search warrants for the premises of the suspects, which was Toshan Pandey, Colonel Naveen Madhu, and also my own offices, the provincial headquarters, the financial section and the procurement section at provincial headquarters. So we applied for the 205s, which enabled us to get enough information to apply for those search warrants, during which we did discover a number of incriminating documents.
Thank you. Then if you can go to your founding affidavit in the KZN High Court, you should have a hard copy there now in front of you. If you look at paragraph 29.7, that picks up where you just left off. It's page 13 of that affidavit.
$29.7.
That's right. You have it? It says there, One of the suspects in the investigation, a colonel in the SAPS, subsequently tried to bribe and pressurize me to compromise the investigation. Is that correct?
That is correct, Madam Chair.
And you go on to say that the said colonel, and that I assume refers to Colonel Madhu, is that right?
That was indeed the case, Madam Chair.
Said Colonel Madhu showed you some photographs which came from the SAPS database, which he claimed would cause you some difficulties. Is that right?
That is right, Madam Chair.
What was your response to that?
Well, Madam Chair, quite frankly, I didn't know what he was talking about because those photographs actually came from police dockets and didn't make sense to me. And I asked him what it was about, and he couldn't explain why he was showing me the photographs in the beginning. And I couldn't make sense of it either because they were normal crime scene photographs where you could see the police cones and the police cording off tape, which actually came from police dockets.
Did he suggest why he was showing you those photographs?
Not really, Madam Chair, but the impression I gained is that he was trying to put pressure on me for something that which I couldn't fathom at the time.
Okay. And then in paragraph 29.8, you say, on the 8th of August 2011, I caused him to be arrested for attempting to bribe me with a 2 million rand payment. Is that right?
That is correct, Madam Chair.
The way in which you caused him to be arrested was that you had what we colloquially refer to as a sting operation. Is that right?
That is correct, Madam Chair.
What happened to the money that you obtained through that process?
Madam Chair, immediately, if I might just say, we did what we call a Section 252A operation in terms of the Criminal Procedure Act, which is authorized by the Director of Public Prosecutions, a designated advocate at the DPP's office, which at the time was Advocate Gernel. He authorized the Section 252A operation. So after a number of meetings with Colonel Madhu, which was all duly recorded in the dockets and reported to Advocate Nel at the time, every single meeting. During the sting operation, we had policemen placed in strategic positions, and the arrangement initially was that the money would be handed over to me at the casino, but he changed at the last minute. So we had to replan, and it was arranged that it would be done in the basement of police headquarters in KwaZulu-Natal, where I worked. Later on during the day, after the people doing the sting operation were in place, I met Colonel Madhu in the basement, during which time he placed amount of money in the boot of my car, and he was arrested. That money was subsequently forfeited to the state. I think it amounted to just under 1.4 million rand.
Thank you. So both Mr. Pandey and Colonel Madhu were arrested as a consequence of this?
Madhu was, well, obviously he was arrested at the time that he had placed the money in my boot. And I think a week or so later, Pandey was arrested after returning abroad. He was arrested at Eyre International Airport when he arrived back in the country.
And you say in paragraph 29.10 of your affidavit that the charges against both the colonel and the businessman were provisionally withdrawn on the 11th of February 2013. Is that right?
That is right, Madam Chair.
Just for completeness, can you tell the inquiry, I believe those charges have been reinstated. Can you explain to the inquiry?
Madam Chair, while after the charges were withdrawn, the investigating officer at the time reported to me that the charges had been withdrawn against Colonel Madhu and Pandey, but he was having great difficulty to retrieve the docket from Advocate Moipone in Maritzburg at the time. I'd written a number of letters. I was suspended, I was arrested. Eventually, after the Gorvin judgment and after I was exonerated in a disciplinary hearing, I went back to my office. Between myself and the then head, well, the current head of IPID, and I also recall that General Dramat had also written to the NDPP at the time, which then turned out to be Advocate Mkolisi in Kasana, to review those matters. And I understand, I think it was about 2 years ago, I was informed that the charges against Madhu and Pandey had been reinstated. As it stands, they had not appeared in front of court just yet, because they took that matter under review, which I believe was struck off the roll a couple of months ago.
And the letters that you wrote, what were they about?
Madam Chair, I was convinced that there was a prima facie case against it too. The evidence was overwhelming, and I articulated that in my letter to the NDBP at the time. And as a matter of fact, I then went to see General Dramat just to tell him that I've written the letter, and he said to me, incidentally, he agrees with me, that, and I was unaware of the fact that he had also done the same at the time.
So it was about trying to reinstate the charges?
Indeed, Madam Chair.
Okay. Then, if you can look at paragraph 29.11 of that same affidavit, you say after Pandey and Madhu were arrested, on the 11th of December 2011, an article appeared in the Sunday Times which stated that the Katomina SVC section was a death squad. You see that?
I do, Madam Chair.
And you say that the article accused you of being complicit in their alleged actions, and that the photographs accompanying the article were the same photograph shown to you by Colonel Madhu prior to his arrest, the photographs we discussed a little earlier. Is that correct?
That is correct, Madam Chair.
Now, you say in paragraph 29.16 of your affidavit, which is over the page, that the inescapable conclusion is that my role in the investigation led to my suspension, because you were then suspended, I believe, after that Sunday Times article.
That is indeed the case, Madam Chair.
Why do you say that?
Madam Chair, if it's just possible, there's just one legal aspect that I think I need to canvass with Mr. Katz, and perhaps it's evidence that I have at my disposal, which I'm not too sure whether I can share it here, which I'm happy to do, but I just want to canvass that with my counsel, if you don't mind.
You may do so.
Thank you, Madam Chair. Madam Chair, at the time of this investigation, right in the beginning, I was informed by Crime Intelligence, Colonel Brian Padiachi, that there apparently were threats that I should be eliminated. I understand at the time that they then applied for Act 70 communication interceptions of Pandey. During those discussions of those intercepted calls, it became clear that Pandey even knew the exact date on which I would be suspended. He actually predicted the date that I would be suspended, and he also predicted the date that Naveen Madhu, the colonel, that at the time was at suspension, that he would return to work, the exact date, and he also predicted the date on which I would be suspended, and he was right on both occasions. As a matter of fact, at the time, I was greatly concerned about it, and before my suspension, I alerted General Dramat at the time that we've picked up this during the interceptions, that Pandey knew exactly when I was going to be suspended.
Well, let's talk then about your suspension. You bear with me for a minute. So you received your notice of suspension, and you then launched an urgent application in the Labour Court, is that correct?
Madam Chair, what happened is I was served with a notice of intention to suspend, but it wasn't clear from the notice why they wanted to suspend me. So I requested my attorney to write a letter to the employer to explain what the allegations against me were so that I could make a meaningful representation why I should not be suspended. The response was quite terse, saying that I know what they were and that they were proceeding with the process. So I immediately approached the Labour Court, obtaining an interdict against the police from suspending me until such a time that they supply me with the necessary information, and we actually listed the information, until such a time that they supply me with that information so that I could make a meaningful representation. In spite of that, in spite of the court interdict, I think it was about 2 weeks later, I was called into an office by a General Ngembe, who handed me a letter to tell me that I've now been suspended. I still asked her, but there's this interdict, and she just shrugged her shoulders, and I immediately phoned my attorney, Katomina Unit. We approached the court. The following day was a public holiday. I recall the judge at the time told the police that he wanted to know by 3 o'clock the following afternoon. I brought in an urgent application, but being a public holiday, the judge ruled that I've not been prejudiced. Of course, it was a public holiday in any event, but he nevertheless gave the police an opportunity to convince him by 3 o'clock the following afternoon not why he should not grant such an order. I then received a phone call from Mr. Katomina Unit the following day saying that the police had asked me to withdraw my application. They will withdraw the suspension. I said, no, I'd rather go to court and make it an order of the court. So we went back to court the following morning, and by consent, my suspension was uplifted, and contempt proceedings against the police were remanded sine die.
Okay, and that sequence of events is in your affidavit before the KZN High Court from paragraphs 34 to 42, is that correct?
That's correct, Madam Chair.
Okay. You ultimately, after these 2 successful applications to the Labour Court, you were in fact suspended on the day that you were charged, or the day you were arrested, I believe. Is that right?
Madam Chair, I was arrested on 22nd of August, and I think I was only suspended 2 or 3 weeks after that.
Okay. Now, I want us to go, there was then subsequently a disciplinary inquiry, is that right?
That is correct, Madam Chair.
And the chair of that inquiry was Advocate Kassem, SC.
That is correct, Madam Chair.
Can we then go to the findings of Advocate Kassem, which are in folder G, item 5.3, and then document 5.3.9. And General Booysen, you have that in your larger file, and it is at page 211.
I do have it in front of me, Madam Chair.
Thank you. Now, so these are the findings of Advocate Kassem, and they're dated 16 September 2014, is that correct?
That's correct, Madam Chair.
And if one looks at these findings, Advocate Kassem makes it clear that the disciplinary inquiry that he was tasked with chairing, was related to the conduct of the Katomina Unit and to your role in supervising that unit. Is that correct?
That's correct, Madam Chair.
And he looked at the Sunday Times article in which you were accused of managing and supervising and supporting the alleged killings of people by the Katomina Unit. Is that right?
That's right, Madam Chair.
If you look at paragraph 16 of that finding, it's page 215. Advocate Kassem says, overall it is contended that the unit was not properly supervised and controlled by Booysen, was undisciplined and brought the SAPS into disrepute. Booysen is accused of mismanaging the unit, and this casts the SAPS in a poor light. Is that right?
That's right, Madam Chair.
And then in the findings, I'm not going to go through all of it, but I'll just take you to the relevant parts. Then at page 218 of the findings, Advocate Kassem begins to evaluate all the evidentiary material that was placed before him. Do you see that?
I do, Madam Chair.
And he says in paragraph 26, no direct evidence was placed before me. This is in respect to the Bongani Mkhize case. You see that?
I do, Madam Chair.
He goes on, he says the witnesses who testified on behalf of the SAPS could not directly implicate Booysen in any wrongdoing. You see that?
I do, Madam Chair.
And he spent some time in these findings going through the Bongani Mkhize case, which was an unfortunate event in which a child was killed, I believe. Is that right?
That is correct, Madam Chair.
And if you go then to paragraph 37, he says, he concludes by saying, I have difficulty understanding the case against Booysen when there was a thorough internal investigation in the Mkhize shooting and no evidence was found implicating any policeman in any wrongdoing in the incident involving the shooting of Mkhize. You see that?
I do, Madam Chair.
At paragraph 40 on the next page, page 223, Advocate Kassem says, the nub of the complaint is that Booysen should have done more to ensure that the court order was complied with, i.e. that police officers were not to pursue or unlawfully harm Mkhize. I find no persuasive reason to indict Booysen of any wrongdoing in the shootout, whereby police officers pursued Mkhize, which resulted in Mkhize being killed. The other complaint is that Booysen was de facto in control of the unit, which was involved in the Mkhize shooting. You see this?
I do, Madam Chair.
Okay. And this allegation that you were de facto in control of the unit finds its way into the charges against you for racketeering. Am I right?
That is so, Madam Chair.
At paragraph 41 of the finding, can you see that? He says, I find there's no basis to justify a complaint of this nature. The complaint he's talking about is in the paragraph above, about you being in de facto control of the unit. Is that right?
That's right, Madam Chair.
And he goes on to say, there's no evidential material cognizable in law to suggest that any police officer acted improperly, and therefore it's wrong to hold Booysen to account for anything untoward. Is that correct?
That is correct, Madam Chair.
Okay. And he goes on to describe the hierarchy within the structure of the Hawks, and he describes two deputy provincial commissioners, that's Masemola and Brown, that were above you. Is that correct?
That is correct, Madam Chair.
He says then it is wrong to single out Booysen in these circumstances as being responsible to conduct any disciplinary inquiry or other investigation those police officers involved in the shooting of Mkhize. You see that?
I do, Madam Chair.
Okay. Now, also of relevance to your criminal charges is the findings of Advocate Kassem in relation to Colonel Eyre. Do you recall that?
I do, Madam Chair.
Do you recall why Advocate Kassem had to look at statements of Colonel Eyre? Colonel Eyre gave evidence before your disciplinary inquiry, is that right?
He gave viva voce evidence, Madam Chair.
Okay. And then if you look at paragraph 43 at the bottom of page 224, Advocate Kassem says the suggestion that the Independent Police Directorate was somehow undermined by Booysen is not supported by any factual content. The evidence of Colonel Eyre, the direct commander of the Katomina Unit, that Booysen in reality controlled the CNU and undermined Colonel Eyre to the extent that Colonel Eyre was rendered ineffective, was unpersuasive, having regard to the content and quality of Colonel Eyre's testimony. Is that correct?
That's correct, Madam Chair.
All right. Now I want you to look at paragraphs 44 and 45 that follow on page 225. In these paragraphs, Advocate Kassem makes certain findings about the credibility of Colonel Eyre's testimony. Do you recall that?
I do, Madam Chair.
Okay. And he says in paragraph 44, I found Colonel Eyre to be a dismal witness in material respects. He is obsessed by the notion of his own importance, and his entire testimony was permeated by his political acceptability and self-importance. I find him not to be the kind of professional policeman one would expect holding the rank he holds. His tenor of evidence, as I've indicated above, is one in which he emphasizes his own importance but lacking in conduct justifying any usefulness. And he goes on and makes quite strident comments about Colonel Eyre's continual employment at the SAPS. Is that right?
That's right, Madam Chair.
In paragraph 45, he talks about Colonel Eyre having what he terms as pure hatred for you. Do you want to comment on that?
Madam Chair, I can't comment on that, but I'll probably keep you busy the whole day with regards to that. So I think suffice that I know that he does not like me at all.
Thank you. You just bear with me a minute. The CASM findings are extensive, but he concludes ultimately at page 238 that the employer, that's the SAPS, had not discharged its onus of demonstrating wrongness on your part. Is that right?
That is correct, Madam Chair.
Okay.
Madam Chair, if you would just allow me to explain to you how this disciplinary hearing came about. After my suspension, which was overturned, I was then arrested post the Gorvin J judgment. Now, in terms of the police disciplinary hearing code, the police must institute disciplinary proceedings against the employee within 60 days. Nothing happened until after Judge Gorvin had set aside the charges against me. In court on the day there, one of the counsel appearing for the police at the time told my attorney, there's another surprise coming our way. Lo and behold, that Tuesday, I think that was on the Friday, lo and behold, on that Tuesday, in the middle of the night, I received a call where I had to meet a police general after hours in Florida Road, where they handed me a pile of documents and told me that they are now starting a disciplinary hearing against me. Normally, it should have happened within 60 days. By then, 600 days had lapsed. So I just found it very strange that just after Gorvin had ruled, that all of a sudden that there's this disciplinary hearing against me.
Thank you. Okay. Now, General Booysen, we've heard at this point about the various statements against you and about the fact that the essential component of what you were charged with was being responsible for and managing this unit that was accused of criminal activities in Katomina. Is that right?
That's right, Madam Chair.
I want you just to explain to the panel, I want to take you through the structure of the Hawks so that the panel can understand how those allegations against you and the charges against you for racketeering, how they sit within the structure. So if you can look, please, at page 506 of the big bundle. And this is at folder J, item 159 and 160 on the Dropbox. There's also a copy at the back of the big bundle of the panel and Advocate Jiba and Advocate Mrwebi's counsel.
You say folder J item?
Folder J, item 159 and 160. I want you please to start For the panel's assistance, if you look at the very back, the last documents in your miscellaneous bundle, so the fatter of the two bundles, there should be 3 pages, there should be 2 pages, 506 and 507. And those pages contain an organogram. Perhaps you can try and rotate the view on the screen, please. There we go. Okay, so General Booysen, these are organograms that you have prepared for these proceedings, is that correct?
That is correct, Madam Chair.
Okay, let's look first at page 506. That is the period, the indictment. You've prepared the organogram in relation to the period of your indictment, is that right?
That is indeed the case, Madam Chair.
All right, so the first one at 506 is for the period May 2008 to February 2010, is that right?
That's right, Madam Chair.
All right. Now, I see that, sorry, you wanted to say something?
2008 to 2011.
Yes, but the first organogram on page 506 relates...
I'm with you. Sorry, Madam Chair.
So as I understand it, let's begin this way. As I understand it, during the period for which you were indicted, the structure of the Hawks changed at some point, is that right?
That is right, Madam Chair.
Okay. So in that first period, from May 2008 to February 2010, which is at page 506, if you look at that organogram, you've put yourself not quite in the middle, I suppose it's towards the bottom there, as provincial commander of the SVC. Can you explain that structure to us? Who did you report to there?
Madam Chair, if I could perhaps start at the bottom, I think it's going to be easier. Right at the bottom you have the name of Lieutenant Colonel Olivier. And then right on top you have the name of Colonel Rajan Eyre. Now, Colonel Olivier was the section commander at Katomina, but Katomina was part of the Durban Organised Crime Unit where Eyre was in charge, Colonel Eyre was in charge. The name Katomina is a misnomer. It's only called Katomina because of where the office is located, but they were actually part of the Durban Organised Crime Unit. So starting from the bottom, Colonel Olivier reported to Colonel Rajan Eyre.
Okay.
Rajan Eyre in turn reported to myself. I in return reported to General Pat Brown, who reported to General Fani Masemolo, and the ultimate commander in the province would be Lieutenant General Hamilton Ngidi. If I could just explain, Madam Chair, there's a difference between a provincial commander in the police and a provincial head. The provincial head is the person that's ultimately accountable and responsible for that component. He has more powers than the provincial commander. So in this particular instance, for the first part of the indictment period, I was a provincial commander reporting to the people that I've indicated above me in this organogram.
Thank you. And then if you go to page 507, this is now for the second period of your indictment. That is for March 2010 to September 2011, am I right?
That's correct, Madam Chair.
Okay, now the structure here looks quite different. Can you run us through your reporting? It looks here that you're reporting both to Lieutenant General Ngobeni and also to Lieutenant General Dramat. Can you explain that structure of who you reported to?
Madam Chair, if it's possible, if you would allow me to rather start from the bottom, it makes more sense.
Yes, start at the bottom.
So once again, Madam Chair, Colonel Olivier from Durban Organised Crime Unit, located at Katomina, now reports to a Colonel Hussein and Colonel Mgwengwe. Now, you'd see, Madam Chair, it says right next to their names, they were the Mgwengwe and Hussein were the acting unit commanders at the time. The reason being, for that period, Colonel Eyre had been removed by the Provincial Commissioner, General Hamilton Ngidi, and he was sent to Ulundi to do some investigations there. He spent 6 months there. There were problems there. He was removed and sent to Pinetown Police Station. At Pinetown Police Station, he picked up problems with the command structure. He was sent to Verulam. So for the latter part of the indictment period, Eyre wasn't even there. So the two people that Olivier reported to then at the time would have been Colonel Hussein and Mgwengwe. Now, Madam Chair, because I'd now been promoted to a higher level, someone had to take over my place. So in abeyance of an appointment of that particular person, I decided to take the 3 senior colonels in the province and let them rotate. They were Colonel Madonsela, Colonel Lats, and Colonel Zikale. Colonel Madonsela was eventually appointed as the permanent provincial commander, who then reported to myself. Madam Chair, you'll see I reported to General Jomat and the provincial commissioner at the time, General Kubeni. Initially there was a dual reporting channel, and I think you would recall that there was this, the Glenister application that landed up in the Constitutional Court relating to the independence of the DPCI. So post Glenister, my command channels was from myself to Jomat to the minister. But for this particular period, it was I had 2 reporting channels to General Nkobeni, the provincial commissioner, and to Jomat at national level from the Hawks.
Okay. When were you, pardon, when were you promoted?
Madam Chair, I was promoted to General in March 2010.
Thank you.
So that we understand correctly, the Katomina Unit, which is at the heart of the charges against you, would have, if we had to draw a line below Lieutenant Colonel Olivier here at the bottom of the page, the Katomina Unit would sit somewhere below that. Is that right?
That's correct, Madam Chair.
Okay. Now, can you go to page 505 of your file, and this is at folder J, item 156. We'll just wait for them to rotate the picture on the screen. This is, there we go. This is a document which was provided to the evidence leaders by Advocate Mayema from his notebooks as part of the development of the prosecution against you. And it shows his structure of how he understood the KZN DPCI. You see that? Can you have a look at that structure for me?
I have already had a look at it, Madam Chair.
Thank you. Now, in this structure, I see Katomina below you, Booysen Provincial Commander DPCI, it says, at the same level as Port Shepstone, HRM Human Resources, and PSS Harbour, I think that says. Is this picture of the structure correct?
It is not correct, Madam Chair.
Why is it not correct?
Madam Chair, well, he's missing out one layer there, and the layer being Katomina, the office Katomina, situated at Katomina, reported to Colonel Eyre, and Eyre reported to me. And that's for the first half of the indictment. The second half of the indictment, Olivier reported to other persons, Mgwengwe and Hussein. So that layer there does not appear on this organigram that's in front of me now.
Thank you. Now, General Booysen, I'd like to go back to the charges against you and specifically to Advocate Jiba's role in those charges because you've now given us some helpful context to the decision that Advocate Jiba took to authorize the charges against you. In order to do so, I just want to take you first to the legislation. Now, you will have a copy of the Prevention of Organized Crime Act. It's at folder A, item 26. If you don't have one in front of you, it will come up on on the screen. Okay, can we look at section 2(1)(e) and F? Can you see it? Can you see it, that screen? Not really. Can we pass you a copy of it? Hold on a minute. Just give me a second. Sorry, Chair, if you could just bear with us. I'll pass my copy, but I'll pull one up on my computer. Can you pass that to me? All right. So the section in front of you, Section 2 of the Prevention of Organised Crime Act, which is colloquially known as POCA. You see that?
I do, Madam Chair.
And you were charged with an offence under Section 2(1)(e) and Section 2(1)(f. Is that right?
That's right, Madam Chair.
Okay. And if you look at page 193 of the big bundle, that is, for the assistance of the panel, that is where the authorization to charge you is contained. It's page 193 and 194. And on page 193, the authorization is in respect of you and 18 other people.
That's correct, Madam Chair.
And they are all charged with a contravention of 2(1)(e). So let's look at what 2(1)(e) says. 2(1)(e) provides that any person who, whilst managing or employed by or associated with any enterprise, conducts or participates in the conduct directly or indirectly of such enterprise's affairs through a pattern of racketeering activity. You see that?
I do, Madam Chair.
And then, at page 194 of the big bundle, is the authorization by Advocate Jiba to prosecute you and 4 others. You see that?
That's correct, Madam Chair.
And that authorization is in respect of Section 2(1)(f) of POCA.
Yeah, that's right, Madam Chair.
And just so we are all on the same page, 2(1)(f) refers to an offence where any person manages the operation or activities of an enterprise and who knows or ought reasonably to have known that any person whilst employed by or associated with that enterprise conducts or participates in the conduct directly or indirectly of such enterprise's affairs through a pattern of racketeering activity. You see that?
I do, Madam Chair.
And then if you go down to Section 2, subsection 4 of POCA, that section says, a person shall only be charged with committing an offence contemplated in subsection 1 if a prosecution is authorized in writing by the National Director. You see that?
I do, Madam Chair.
Okay. So that when we talk about the decision by Advocate Jiba, that is the decision that you sought to review in the KZN High Court. Is that right?
That's right, Madam Chair.
And then you were subsequently charged again under Sean Abrams. Is that right?
That's right, Madam Chair.
And you are reviewing that charge as well?
That's indeed so, Madam Chair.
And that review is pending at the moment, is that right?
That's right, Madam Chair.
Okay. Now I want to take you to the prosecution policy, which is folder A, item 13, page 5. You'll see it up there on the screen in front of you, and it's headed General. Are you aware of this prosecution policy?
I am, Madam Chair.
Have you had occasion to look at it?
I have, Madam Chair.
All right. So this policy is a guideline. We've heard by previous witnesses have told us that this policy is a guideline to prosecutors of how to practice. And if I take you down under general, it says the process of establishing whether or not to prosecute usually starts when the police present a docket to the prosecutor. This often happens after the suspect has been arrested, and the case needs to be studied to make sure it's properly investigated. You see that?
I do, Madam Chair.
And then under the bullet points.
Sorry to interject, Ms.
Uh-huh.
Is this witness now an expert on how the NPA implements their policy and how they must understand it? Surely this is there for us to read and argue at the end of the matter.
What's the intention of the evidence?
Thank you, Chair. The intention wasn't to ask for an opinion on the policy, merely to give you the context of the policy, but I'm comfortable that we leave that for argument. That's fine.
Thank you.
If you just bear with me for a minute.
Maybe Advocate Katz will be a better witness.
I'm not sure Advocate Katz wants to be a witness.
Madam Chair, if I could perhaps just add, as far as I
It's
know,
not now.
that's a public document.
Yes.
Proceed.
Thank you, Chair. General Booysen, we move on to the charges against you. A central part of the charge against you is that you managed and supervised the Katomina Unit's criminal conduct in return for a monetary award. Is that right?
That's correct, Madam Chair.
And the monetary award that's referred to is an award of 10,000 Rand that is awarded by the SAPS for good service by its officers. Is that right?
That is right, Madam Chair.
Who decides how those awards are given?
Madam Chair, maybe I should explain the whole process to make it easy for everyone. It's allowed for in the police regulations that awards can be given to police officers that have done good work. There are different categories. What normally happens is that there will be an application that will be sent to, from the unit itself. If the unit commander thinks that the work warrants such an award, they will then forward that to provincial headquarters. At provincial headquarters, at my level, I will look at it and I will then send it to my immediate supervisor, which will be General Brown. He will look at it, and if he feels it's warranted, he will send it to the provincial commissioner. The provincial commissioner gives it to a committee who sits. That committee then makes recommendations to the provincial commissioner. Once the provincial commissioner is satisfied, he will send it to national head office. There a committee of senior generals will sit, and they will once again look into the merits of the matter, and they will then finally decide whether it's warranted for those individuals to be awarded or not. In this particular case, I would just like to draw your attention to the fact when it was sent to my office, because my name was on the list as a possible recipient, I did not feel comfortable recommending or signing off on my own recommendation. So I forwarded that to my immediate commander to dispose of. I did recommend to him at the time, but I agree with the contents thereof. But in his own handwriting on that document, he recommended the award. It went through the whole process right up to national level, where it was eventually approved.
Did you have any guarantee that you would be given this award because of the conduct of the Katomina Unit?
Not at all, Madam Chair. It often happens that applications like this would go in and it would come back from either of those committees where they will say this was during the normal scope of your duties or for whatever reason. So there's absolutely no guarantee that such an award would be given to anyone.
And you, in this case, were awarded a once-off award of 10,000 Rand, is that right?
That's correct, Madam Chair.
And how did you understand the reason for you being awarded that 10,000 Rand?
Madam Chair, one is to look at the memorandum that went in and right up to head office. One of the suspects that had been sought for the killing of a police colonel, Colonel Tonko, I received information from an informer while sitting in my office as to the possible whereabouts of this individual, which I related to the investigators. They subsequently located the suspect, and during a shootout with them, the suspect was killed. So that was the sum total of my involvement in that particular matter. One phone call that I received and one phone call that I conveyed to the investigators.
Okay. Now,
just clarify, what was the award about when the suspect was killed? Was it for killing the suspect?
Madam Chair, without being facetious, I think that's what the prosecution wants us to believe. Definitely not.
Thank you.
General Booysen, I now want you to go to Advocate Jiba's answering affidavit, which is in folder G, item 5.1.31. We'll just wait for it to be called up. And I want us to look at paragraph 16, please. Okay, so this is Advocate Jiba's response in the KZN High Court application, which you reviewed the decision to authorize your prosecution. Now you see in paragraph 16, Advocate Jiba says, after due and careful consideration of the information under oath and the evidence as contained in the dockets, copies of which were made available to the applicant, the respondents were and still are satisfied that there is prima facie evidence that an offence has been committed and that the applicant is implicated in that, 16.1, from January 2007 to March 2010, the applicant was a provincial commander in charge of the KwaZulu-Natal organised crime. Subsequent thereto, and in 2010, he was appointed as the provincial head of the newly established Directorate for Priority Crime Investigations in KwaZulu-Natal. And she goes on to explain how, in paragraph 16.2, how the Serious Violent Crime section based at Katomina was incorporated into the Durban Organised Crime Unit. We've been through that structure already. If you skip to paragraph 16.5, she says the information before me suggested that these members of the SAPS would in most of the killings place a firearm next to the deceased person to create the impression that she or he was armed and had attacked the police by shooting at them or endangering their police lives. And 16.6 over the page says the information under oath which was placed before me also indicated that the applicant knew or ought to have known that his subordinates were killing suspects, as aforesaid, instead of arresting them. In 16.7, she refers to the fact that the information further revealed that the unlawful activities of killing suspects and or civilians were in certain instances motivated by the applicants and members of his unit's desire to enrich themselves by state monetary awards and or certificates for excellent performance. And she attaches an example of a monetary award claim where you're recommended for that award. We've discussed that. And then in paragraph 17, Advocate Jiba says, particular reference is made in this regard to the statements made by Colonel Rajendran Sanjeevi Eyre, Mr. Aris Danikas, and Mr. Ndlondlo, from which it is apparent that the applicant is well aware of the information that the respondents have in their possession relating to the murder of at least 28 people and the monetary and non-monetary awards claimed by him for the instrumental part that he played in these crimes. And then she says, additionally, Mr. Danikas has revealed some of the information he's provided to the respondents and to the press and even posted video footage on YouTube. So Advocate Jiba appears to say that part of the evidence that she considered before her was the statements of Eyre, Danikas, and Mr. Mtiani, who's known as Lordlo. Is that right?
That's correct, Madam Chair.
Okay. And then at paragraph 21, she says, these are only some of the instances that are referred to in the statements, where she detailed some of the instances. And she says the statements which were considered together with the other information in the docket before the impugned decisions were made. Now, you told us earlier what you saw in the docket. You had recorded in writing in annex, which is contained in Annex A to your affidavit. Is that right?
That's right, Madam Chair.
Okay. So to your understanding, what was in the docket was not the statements of Eyre, Danikas, and Londlo. Is that right?
Madam Chair, it's not my understanding. They were not there.
Okay. And what was in the docx is listed in Annex A, and if one casts one eye over that, it's page 20 of the smaller bundle, it doesn't appear that you are referred to it anywhere in those documents. Is that right?
That's right, Madam Chair.
Okay, now I'd like you to please go to the judgment of Gorvin J. in the High Court. That is in your big bundle. And it's at page 451. And can you please look at page 465 of that judgment, paragraph 25. You have that?
Which paragraph?
Paragraph 25. If you'll just give us a minute, Chair, we'll find it on the Dropbox. It is in bundle B, and it's number 1 in bundle B. All right, and if you can please go to paragraph 25 on page 465. Right. Now, at paragraph 25, Judge Gorvin says, it's common cause that after the indictment was served on Mr. Booysen, the NDPP was requested to make available all the documents on which the state intended to rely. In compliance with that request, 23 dockets were made available. These were the only documents furnished to him prior to the launch of this application. You see that?
Do, Madam Chair.
Of the 23 dockets, he's mentioned in only 2. Of 290 statements in all of the dockets, only 3 statements even mention him. 2 of these say he arrived on the scene of a shooting in a helicopter after the event, and the third states that he was noticed on the scene of the shooting after it had taken place. In response to Mr. Booysen's assertion that no statements in the dockets implicate him, the NDPP says that she relied on 4 statements on oath. We've discussed those 4 statements, is that right?
That's right, Madam Chair.
Copies of which she says she annexed to her answering affidavit. And then Judge Gorvin says, what is clear, however, is that this in no way challenges the averment of Mr. Booysen that none of the documents in the dockets implicates him in the offences in question. You see that?
I do, Madam Chair.
If you turn then to paragraph 28, paragraph 28, Judge Gorvin says, on a factual level, therefore, she states and he's referring to Advocate Jiba, that there were only two categories of information on which she based the first impugned decision. First, the contents of the dockets, and secondly, statements under oath, which she says are annexed as NJ 2, 3, 4, and 5. You see that?
I do, Madam Chair.
In paragraph 29, she says, as regards the contents of the dockets, the respondents conceded in argument that no statements contained in them implicate Mr. Booysen in any of the offences with which he has been charged. Now, I understand that there's some dispute subsequent to this judgment about whether or not such a concession was made. We can take it for present purposes that that the understanding was that of the judge was that there were no statements in there that implicated you, not necessarily that Advocate Jiba had agreed to that statement. Is that right?
That's my understanding, Madam Chair.
Okay. Paragraph 30, the judge says this leaves the four annexures to the answering affidavit.
Sorry, Madam Chair, there is a statement by Advocate Lawrence Mrwebi, SC, who was in the matter, which perhaps Ms. Raja Badlinde should refer to or take the witness to. There is a statement in the Dropbox by Advocate Lawrence Mrwebi, who appeared for the NPA, and he deals with the alleged concessions made in court.
Yes, thanks, Mr. Arnza. There is such a statement. I don't know where it is exactly on the Dropbox right now. We'll find it and make it available. J80. And that's why I said, for present purposes, we're not suggesting that Advocate Jiba conceded that the statements did not implicate him. I'm accepting Advocate Hose's position. I'm simply putting the position of the judge to the witness at this point. So, General Booysen, if you can then...
The IT people or the recording people are asking for how many? 5-minute break? Yeah, for recording purposes. It's okay? If anybody goes out, kindly be back here within 5 minutes. We adjourn for 5 minutes.
I even replied to your... Oh, where? There. Was I saw you up there. I was like, did you even the phone? Yeah. Same man, sorry about the phone. Nope. Ask phone. Okay.
That guy with the short from yes, under the policeman. Who's responsible for the life of this country?
Thank you. Thank you, Chair. Chair, just before we broke, there was a question about Advocate Hodis's opinion. Can I just refer you to the Dropbox at folder G, and just for your reference, there is a transcript of the proceedings at which the question of what Advocate Jiba had conceded or on her behalf was conceded or not. The transcript is at folder G, item 5.1.4.8. Sorry, folder G, 5.1.48. And that is the transcript of the proceedings. But I'm not going to go there, and if Mr. Arnser would want to cross-examine on that, of course he's welcome to. I just point you to where that is in the bundle.
Okay, thank you.
Then General Booysen.
Still early in the week and early in the day.
It's early in the week and early in the day, yes. General Booysen, if we go back to the Gorvin judgment, I'm looking now at page 465 of that big bundle in front of you. We looked at paragraph 25, and I want you then, sorry, to just turn a bit further along to page 469. To paragraph 31, that's where we'd stopped. Now, in paragraph 31, Judge Gorvin says, the submissions of Mr. Booysen in his replying affidavit can be summarized as follows. 2 of the annexures are sworn statements made under the name of one Colonel Eyre. These are annexures NJ2 and NJ4, respectively. Mr. Booysen describes these as statements which concern, quote, office politics, and submits that they in no way implicate him in any of the offenses with which he's been charged. We dealt with that earlier today. The second of these, in addition to not implicating him in any of the offenses in question, was deposed to on 31 August 2012, some 2 weeks after the first impugned decision was taken. You see that?
I do, Madam Chair.
Then it goes on to say the document referred to as a statement by Mr. Danikas, Annexure NJ3, is not a sworn statement. It is not even signed by anyone. It's not dated. Even if it can be attributed to the named person, and even if it was a sworn statement as claimed by the NDPP, the contents do not cover the period dealt with in the indictment, except for one event which does not relate to Mr. Booysen. As regards Annexure NJ5, this does not implicate Mr. Booysen in any of the offences in question. You see that?
I do, Madam Chair.
And paragraph 33 says, in argument, the respondents did not in any way challenge the above factual submissions concerning the nature and content of the annexures in question. The factual submissions appear to me to be accurate, says Judge Gorvin.
I see that, Madam Chair.
Then paragraph 34 of that judgment, it says, Mr. Booysen was clearly within his rights to deal in reply with the inaccurate assertions by the NDPP in her answering affidavit and to issue the challenge and invitation in question. He had not seen the statements until they were annexed to the answering affidavit. As regards the inaccuracies, the NDPP is, after all, an officer of the court. She must be taken to know how important it is to ensure that her affidavit is entirely accurate. If it is shown to be inaccurate and thus misleading to the court, she must also know that it's important to explain and, if appropriate, correct any inaccuracies. Is that correct?
That's correct, Madam Chair.
All right. And then Judge Gorvin goes on to deal with the absence of a response by the NDPP and the failure to deliver a further affidavit in response to an invitation to do so by you. And further down in paragraph 34, Judge Gorvin then says that the court is therefore entitled to draw an inference adverse to the NDPP, and the inference in this case need go no further than that on her version, the NDPP did not have before her Annexure NJ4 at the time, In addition, it's clear that Annex to NJ3, it's Danika's, is not a sworn statement. And Judge Gorvin says, most significantly, the inference must be drawn that none of the information on which she says she relied linked Mr. Booysen to the offences in question. This means that the documents on which she says she relied did not provide a rational basis for the decisions to issue the authorizations to charge Mr. Booysen for contraventions of 21E and F, respectively. You see that?
I do, Madam Chair.
So that was essentially the conclusion of Judge Gorvin, that the decision to authorize your first prosecution was irrational. Is that right?
That's correct, Madam Chair.
Okay. Now, if you look in the big file, you'll see at page 157, it starts at 157, and it goes on to 158. This is, it's in the bundle item 5.3.5, if that assists. It's G5 and then 5.3.5. Yeah. That is an application for authorization in terms of section 2.4 of POCA. And it, you will see, is dated 15 August 2012. And it's from Advocate Noko Mashilo to Advocate Jiba. Do you see that?
I do, Madam Chair.
And it says that it's an application for authorization for prosecution in terms of section 2.4 of POCA. If you turn over, it's accompanied by a Prosecution Memorandum at page 158. And that memorandum, I believe, was prepared by Advocate Mayema. Is that correct?
That's correct, Madam Chair.
On page 192, it's signed by Advocate G.S. Mayema. Now, this memorandum, I mean, it's a substantive memorandum. It runs from page 158 to 192. And have you had occasion to look at this before?
I have, Madam Chair.
The prosecution memo is what was presented to Advocate Jiba together with all of the other evidence that we've looked at. And it's generally done in order to make recommendations for the decision that is to come. You're aware of that?
I am, Madam Chair.
Okay. At page 166 of this memo, Advocate Mayema provides an analysis of the evidence to support his recommendation, and Advocate Noko's recommendation that you be prosecuted.
That's correct, Madam Chair.
And at paragraph 20 appears to be the high watermark of that analysis. It says, at all relevant times to the indictment, accused number 1 was the provincial commander, Organised Crime KZN, and later was appointed as the provincial head DPCI KZN during 2010. Accused number 9, that's not you, was the section commander of the SVC section based in Katomina, while accused numbers 6, 15, and 16 were group commanders within this section. The majority of the remainder of the accused were members of this SVC section, whilst other accused were co-opted from other units. You see that?
I do, Madam Chair.
Okay. And that, in paragraph 20, is sought to justify what she refers to in paragraph 17 above. The enterprise is defined to include any individual, partnership, corporation, association, or other juristic person, etc. And that's taken from the statute. Okay. Now, this appears to be a thoughtful prosecution memo. Why would you have any reason to think that an experienced prosecutor, in fact 2 experienced prosecutors, Advocate Noko and Advocate Mayema, would not have carefully considered the evidence before placing it before Advocate Jiba in order to put her in a proper position to make the decision whether or not to charge you.
Madam Chair, I don't think I understand the question.
Let me put it differently. 2 seasoned prosecutors considered that there was sufficient evidence to prosecute you. Now, perhaps it's best that I mean, your position, as I understand it in the litigation, was that there wasn't sufficient evidence before her to charge you. Is that right?
That's right.
Okay. And having looked at this prosecution memo, do you change that opinion? Your opinion?
No, I don't, Madam Chair.
Okay. I want to take you to one more document. I'm coming towards the end of my my stint here, if you'll bear with me.
The date of this memo?
The prosecution memo, yes. It's dated 15 August 2012. And it's item 5.3.5 in bundle G.
Item?
5.3.5 in bundle G.
Sorry, can I just get clarity? I see the memo from Advocate Noko is the one that's dated 15 August 2012. I would like to know what is the date of the one that comes from Miami.
Thank you, Ms. Vilakazi. The prosecution memo appears to be attached to that recommendation of 15 August. It was submitted together, but it itself is not dated. I believe we have another copy of that somewhere in the file that may well be dated. I'll have another look and let you know. Now, if we could then go to folder J, item 79, please. And at the same time, General Booysen, if you could look at page 135 of your bigger file. Item 79 in folder J, which is now up on the screen, is a legal opinion on the prosecution of Ms. Jiba. So it's a much later document. It's dated 5 August 2015. General Booysen, I don't think you have a hard copy of that opinion, but if you could have a look at it on the screen.
Okay, thank you, Madam Chair.
I just want to explain what these 2 documents that I'm referring you to are.
Okay.
The first one is an opinion dated 5 August 2015. And that's an opinion that comes from Advocate Jan Ferreira and Advocate Gerard van Eerden. And it is sent to Mr. Sean Abrams as NDPP and Mr. Marshall Mokgatle, who is the Senior Deputy Director of Public Prosecutions. Okay? And this opinion relates, it's dated 5 August 2015, so it's some years after your initial prosecution. And it relates to a recommendation to prosecute Ms. Jiba. Okay. That memorandum is accompanied by what the document at page 135 of your bundle, which is a PowerPoint presentation by Advocates Ferreira and van Eerden, who wrote the opinion. And I just refer the panel to the PowerPoint presentation for ease of reference, but I'd like to take General Booysen to the opinion. The 2 documents should, I think, be read together. Now, you'll see in this opinion from Advocate Ferreira, who has already given evidence here to this inquiry, you'll see in this document that Advocate Ferreira assesses the case against you and what was before Advocate Jiba. And he says, if you look at paragraph 22 on the screen, he says it's uncertain how the prosecution team and the Katomina prosecution team, intends to get past the evidence that primer residue was found on the hands of the deceased. Just explain to us what's primer residue?
Madam Chair, I'm not a ballistic expert, but in my experience, primary residue is when you fire a firearm, the residue that comes out from the percussion cap in the cartridge deposits certain chemicals on your hand or your clothing.
Thank you. So he says it's uncertain how the prosecution was going to get past the fact that the deceased had primer residue showing that they'd used firearms. Now, Advocate Ferreira and Van Eerden then go through in this opinion and point out several weaknesses in the case against you. I just want to take you through them and see if you agree. It says at paragraph 23, Booysen, having been aware that the hands of those deceased tested positive, could reasonably have believed that the SAPS members indeed acted in self-defense. This must and does act in his favor and will affect his knowledge of wrongfulness on the charges in the indictment. You see that?
I do, Madam Chair.
And then in paragraph 24, he refers to the fact that certain inquests were finalized after the prosecutor decided not to institute prosecution against any of the Katomina Unit. So he says members and an independent judicial officer ruled that nobody could be held responsible for the death of certain of the deceased. So they'd conduct an inquest and closed it. Is that right?
That's right, Madam Chair.
And there are 4 deceased in relation to which inquests were held and found that no one was liable. Is that right?
That's right, Madam Chair.
Okay. And in paragraph 25, he then concludes that if public prosecutors declined to prosecute and inquests were held absolving Katomina Unit officers of any guilt in the deaths of the deceased, then Booysen certainly could rely on these facts, which leaves no room for any other belief than that the Katomina Unit members acted lawfully. You see that?
I do, Madam Chair.
And if you go down to the bottom of paragraph 26, he says, in all of these counts, the state would either find it impossible or at the very least very difficult to convince any court of the guilt of Booysen. You see that?
I do, Madam Chair.
In paragraph 27, he says to add to the problems of the state, both in general, but particularly when evaluating possible evidence against Booysen, it must be noted that in many instances no identification parades were held. Is that right?
That's right, Madam Chair.
Were you aware of any identification parades being held in your case?
Not at all, Madam Chair.
He goes on to say witnesses merely refer to Katomina Unit members by race. In many instances, the firearms of the individual members were not tested to link it to the bullets that killed the deceased. And the Katomina prosecutors will have to rely on statements made by the suspects themselves to link them to a specific shooting. This, however, does not impact directly on the decision to prosecute Booysen, he says, and so they don't expand on that. If you turn over the page, I'm not going to take you through in detail, but in this section, Advocates Ferreira and Van Eerden discuss the evidence of Colonel Eyre. And they say in paragraph 28, from her affidavit, it's clear that Ms. Jiba relied substantially on the statement by this witness, that's Colonel Eyre. And in paragraph 29, says that the complaint was largely dedicated to a complaint session about how Colonel Eyre was victimized, his cell phone was bugged, and how he was transferred in November 2011. You see that?
I do, Madam Chair.
And he alleges that he was a victim of Booysen, and every time he raised the issue, he was targeted. You see that?
I do, Madam Chair.
Do you want to respond to that?
No, Madam Chair.
Okay. Now, this opinion goes on, evaluates the findings of Nazir Kasim SC, which we've already done this morning, and looks also at the prosecution memos that were before Advocate Jiba when her decision was taken. So I want you just to turn to paragraph 49, please. Well, you don't have to turn, it'll come up on the screen. Here the 2 advocates say there are 2 prosecution memos. However, neither of them has set out the evidence that links Booysen to the offences in the indictment. Although the correct legal exposition is given regarding racketeering, the facts of this case are not applied to the law, to demonstrate how the facts support a racketeering prosecution against Booysen. There is no précis of the evidence that any witness will provide, nor is there any indication as to what they allege. The two memos simply refer to categories of evidence such as crime scene photographs, ballistic evidence, eyewitness evidence, etc. None of these categories could link Booysen, as he was only on 2 of the crime scenes, albeit after the fact. You see that?
I do, Madam Chair.
So, after some 23 pages of analysis of the charges against you and the relevant law, Advocates Ferreira and Van Eerden raise concerns about the validity of the charges against you and of Ms. Advocate Jiba's role in approving those charges. Ultimately, they, if you look at paragraph 84, recommend that that a prosecution be instituted against Advocate Jiba, and they say that it's in line with the prescripts of the prosecution policy in the NPA Act. Now, General Booysen, during our break, you indicated to me that there was a question that I'd asked you earlier that you felt you hadn't answered completely. I had asked you whether or not you had a sense of why you were charged in circumstances where you thought the evidence did not support that charge. And you indicated that you did want to respond to that question, so I invite you to do so.
Thank you, Madam Chair. Madam Chair, there were 2 significant things that happened while this investigation was ongoing against Toshan Pandey, over and above the fact that I was under pressure from the Provincial Commissioner to stop the investigation. During the investigation, it came to light that 60 million rand of contracts had been acquired by Toshan Pandey from the police. The investigators informed me that 45 million rand had already been paid out and the remainder was about to be paid out. I immediately wrote a letter to our financial services and our legal services instructing them not to pay out the 15 million rand because it was subject to a corruption investigation. A while later, my secretary said to me that she'd received a call from, at the time she said to me, the brother of the president, Mr. Jacob Zuma. So I said to her, what is it that you want? And she said, no, he wants to meet with you. So I said, well, let him meet with me. And unfortunately, she took ill and she had to go for a mastectomy to hospital. And on her return, she received a similar call. She then said to me, no, the brother of the president wants to see me. And I said to her, okay, where does he want to meet? And he wanted to meet me somewhere. And I said, look, I prefer to meet in my office so that it's properly recorded. It then turns out, on the day that he in fact did come to my office, it turned out to be the son of the erstwhile president, Mr. Jacob Zuma, the son being Edward Zuma. We exchanged greetings, and while after we had exchanged greetings, he indicated to me that there's an issue he had to discuss with me, and it related to the 15 million rand which I'd frozen. So I said to him, well, what's your interest in this matter? And he indicated to me that he was a silent partner of Toshan Pandey, and that he was not getting his dividends because I'd frozen the money and he would like me to release the money. And I told him, look, if I do that, I'll be complicit in corruption myself, and obviously I'm not going to do that. I actually told him, I said to him, Edward, take advice from, not from a policeman, say a friend. Go to Toshan Pandey, tell him, he actually told me that he had invested 900,000 rand with Toshan Pandey. I said to him, go to Pandey, those were my words, ask him you want your money back, take your money and walk away and never look back again. Subsequent to that, a couple of months later, I received a call from a friend of mine who happened to be at Nkandla, who also knew Edward Zuma. And he said to me, hold on, someone wants to speak to you, and it was Edward on the line. And we joked, and I said to him, I hope he heeded my advice, and he laughed and he said that he had indeed heeded my advice, which he obviously did not. That's the one thing. During the investigation, we were running a legitimate Act 70s, that's the interception of communications between Tasha Pandey and a few other people. On the day of the arrest of Colonel Naveen Madusa, obviously the evidence will show that the money was handed to Colonel Madu by Tasha Pandey, who then came to my office and he was going to give me the money. And in exchange for that, I was going to give them a document that would compromise the investigation. I did not want the document to leave. That's why we terminated the operation there and then. So on the Act 70s, it's clear that subsequent to Colonel Madu's arrest, Pandey became frantic because Madu was not returning with a document. And he started making calls to a number of police officers. One of them was to the provincial commissioner at the time, but he couldn't get through. I think she was detained with a meeting in Pretoria. One of the calls was made to a person by the name of Dibo Mzobe. Dibo Mzobe is the nephew of the erstwhile state president, Mr. Jacob Zuma. During this discussion, I will not repeat the exact words because they were not very nice words about me. And it was indicated that for me having the temerity to arrest them for trying to corrupt me, I was being called a mafia leader, and they decided there and then, in the words that Dibo Mzobe used, is Booysen's wings will be clipped. And I think that's very significant that those two particular issues, Edward Zuma having come to my office wanting me to release the money, which I refused, and also Dibo Mzobe, who's a direct family member of the then state president, saying to a suspect that we are investigating that my wings will be clipped.
And General Booysen, just so I understand you correctly, you're suggesting that series of events explains why Advocate Jiba took a decision to authorize your prosecution.
I would say inter alia, Madam Chair, because there were other investigations that I was also involved in, and I think I did speak to that in my affidavit. But I think that's one of the reasons.
Thank you, General Booysen. I don't have any further questions, Chair.
Thank you. Thank you so much, Nasrin. You had indicated that you would want an opportunity to consider some of the evidence before you cross-examine.
Yes, Madam Chair. I think we are fortunately at a point where it might be convenient just to take the lunch adjournment for an hour or so and come back after.
I think we would be inclined to do that so that you get sufficient time to consider how you're going to approach your cross-examination.
Thank you, Malini.
Thank you. Mr. Booysen, we will resume after lunch with you, okay? And kindly know that you are still under oath, and you will then be subjected to cross-examination. Okay, thank you. We will adjourn until what? It's 2 o'clock.
Another food is not ready. Yeah. Past 2. Past 2. Yes. No, 2 is fine. But I'm saying the food is not ready for the other people yet. Just make it 2. Just because you're gonna have food. No.
Can I noticed that the food is not yet ready, but it is there. Yes. Can I venture 2:15? Can I try that? If we're not ready, you will kindly let us know. Is that all right for everybody? Thank you. We'll adjourn until 2:15.